Hello, and welcome to Immigration Talk, a space where we hear from an expert on matters related to the immigration industry, law and policy, and practice. I'm Rosalie Van Staldeinen, and joining me is RCIC-IRB Tiffany Osman-Chi. Welcome, Tiffany.
Thank you for welcoming me back, Rosalie.
It's always a pleasure. Tiffany, how might you advise immigration practitioners with respect to the new citizenship legislation? What do they need to know?
Well, this is a very interesting and very debated topic, Rosalie. So today we're going to discuss that. Many practitioners are now receiving lots of questions following those recent changes. There are clients claiming citizenship through their parents, through their grandparents, sometimes even through their great grandparents. And they're asking themselves whether they are already Canadian citizens. So, how do we figure this out for these clients? Let's backtrack a bit and talk about the relevant historical point of previous Citizenship Act. So before 1977, the Citizenship Act of 1947 was unfortunately rooted in gender discrimination and bureaucratic processes. A Canadian mother could only pass on citizenship if their children were born out of wedlock outside of Canada. So Canadian women actually lost their British subject status before 1947 if they married foreign men and settled outside of Canada. Children born to these Canadian women could not claim Canadian citizenship. Children born to Canadian fathers could claim Canadian citizenship, but they had to be registered within 2 years of their birth. And they also then had to register a declaration of retention if they wanted to keep their Canadian citizenship after their 21st birthday. The 1977 Citizenship Act addressed quite a few of these issues, but they kept the same retention requirements before the age of 28, or it required those children to establish residence in Canada. But not many people knew about this. So there were tens of thousands of people who either missed the opportunity to register themselves before they turned 28, or they never even knew about it in the first place. So Bill C-3, which became law on December 15th, 2025, was called the Lost Canadians Bill by the media and many people in the public. They're not wrong because it reaffirmed the right to citizenship that cannot come with arbitrary restrictions. So it gave Canadian citizenship to many people who were not considered Canadian citizens at the time. Many people are still under the mistaken belief that it automatically granted citizenship by descent to all those born abroad to a Canadian parent before the coming into force of the legislation. And that's true to a certain extent, but that's still a common misconception. My grandparent was Canadian, so I must be Canadian too. Possibly, but the client needs to confirm whether their parent actually acquired citizenship. So in some cases, this does require the parent to apply for proof of Canadian citizenship before your client would actually be able to claim Canadian citizenship in turn. So do not assume that the parent ever became a Canadian citizen. The key question, there are two of them, are did the parent ever apply for proof of citizenship? If the answer is no, then that's the first thing to address. Next, ask the client, was their parent born before or after 1977? And was the parent born in wedlock? So let's take a look at some of these provisions under the current paragraph 3.1 of the Citizenship Act that would apply in these cases. Obviously, under 3.1a of the Citizenship Act, a person is a Canadian if they were born in Canada. This does not change, and it has not changed for decades. For someone born outside of Canada after February 14th, 1977, they would be a Canadian only if they had a parent who was a Canadian citizen at the time of their birth. And this is under paragraph 3.1b of the Act. And it's a second part that we need to address for your clients that are trying to claim citizenship through a parent or a grandparent. So this leads us into paragraphs 3.1f, G, and I. This restored Canadian citizenship to people who lost citizenship due to those discriminatory laws in the old Act. So if a person was born abroad in 1965 to a Canadian mother and they did not apply for citizenship during the 2009 or 2015 amendments, then they would be a Canadian citizen now. Or if they were born abroad in 1970 to a Canadian parent but they did not apply to retain their Canadian citizenship before age 28, then they would not have been Canadians back then, but they would be granted citizenship now, or they would have their citizenship restored to them. Their children would then also be Canadian citizens because of paragraph 3.1b, people who are born outside of Canada to a Canadian citizen. Now, under paragraph 3.1h, these people's Canadian citizenship would be retroactive to their date of birth. This means that if they were born outside of Canada, they would be Canadian citizens to their date of birth, not when the citizenship was issued, which could be now that they're adults, 2025 or 2024. For people who are trying to trace Canadian citizenship to their grandparents so that their parents and themselves can get Canadian citizenship, we need to look at paragraph 3.1k through 3.1r. Paragraph 3.1k allows for people, mostly women, who were born in Canada as British subjects before 1947, but then they lost their status because they married a foreign national. Or they were people who became citizens of another country because in 1947, the Canadian Citizenship Act back then did not allow for dual citizenship. So these people born before 1947 would regain their Canadian citizenship. Paragraph 3.1.0 applies to the children of these people born before 1947. So you could have a Canadian woman born in 1905 in Canada, but married a US citizen in 1925 and had children before 1947. These children would regain their Canadian citizenship. Paragraph 3.1l applies the same way, but for people who were born before 1949 in Newfoundland and Labrador, because that's when they became a province of Canada. And so the people born there would have become Canadian citizens in 1949. Paragraphs 3.1m and n apply to people born abroad who lived in Canada in 1947 and 1949, but did not apply to become naturalized Canadian citizens under any of the previous Citizenship Acts. They are now Canadian citizens. Same thing, their children would be Canadians under paragraph 3.1.0 and p. One important note is that the second generation limit is still in place. So children born abroad after December 15, 2025, which is when the bill became law, to parents who were also Canadians born abroad, will only have Canadian citizenship if their parents can prove establishment in Canada, or if they have resided in Canada for at least 1,095 days before their birth. So this would apply to first generation Canadians born abroad who wish to have children outside of Canada. They need to establish themselves in Canada first for at least 1,095 days before they have their children who are born outside of Canada. So if you're in a situation where your client needs help determining if they are entitled to Canadian citizenship, make a chart. Match theirs, their parents, and their grandparents' situation to one of the provisions under paragraph 3.1 of the Citizenship Act. Confirm the legal framework that applies at the time of their birth and whether they are captured in any of the retention rules. So this is why I said that making a chart is really important, because you can outline to the client where they fall in the current provisions, where their parents fall, and whether they are entitled to Canadian citizenship. Rosalie?
Great. Well, thank you, Tiffany, for walking us through the historical context as well as the current implications of the changes or updates to the citizenship legislation. Thank you very much.
You're very welcome.
Let's talk again.